There are four types of ex post facto laws. The first type is a law that makes an action done before passing of the law criminal and punishes the action. For example, suppose a new law goes into effect tomorrow that criminalizes talking on cell phones while driving. Anybody that has talked on cell phones while driving before tomorrow would be free from prosecution because the law did not exist at the time the behavior happened. The second type is a law that aggravates a crime or makes it greater than it was when committed. For example, suppose Texas makes a change to its indecent exposure statute that makes the offense a felony if committed within 1,000 feet of a school. When the law takes effect, John is awaiting trial for indecent exposure that he committed across the street from a junior high school. Because the behavior happened before the change that aggravates the offense, John is not subject to the felony enhancement. The third type of ex post facto law is a law that changes the punishment and inflicts a greater punishment than the law attached to the crime when it was committed. For example, suppose Texas changed the punishment for burglary of vehicles from a Class A misdemeanor to a state jail felony. Anyone who had an offense date before the law took effect would be subject to the misdemeanor charge and not the felony charge. And finally, the fourth type of ex post facto law is a law that alters the legal rules of evidence to require less or different testimony than the law required at the time of the commission of the offense in order to convict the offender. So, for example, suppose there is a constitutional amendment that reduced the number of witnesses needed to testify to the same overt act in order to convict someone of treason. Because this rule would make it easier to convict an offender, it would not apply to offenders who had already committed a treasonous act. It would only apply going forward in time.